Breaking news about Mountain Echirima, Tamale High Court declare for by-election and answer rerun of a year Kpandai Constituency. Say yenkoto abano fufro. Na 2024 election no omokoto abano omoto abawie no eye NPP candidate ena cheso win ye a friend say eye honorable eye Matthew Nyindam ono ena cheso ye NPCC a chese wokọ eye 2024 election ma eye NPP candidate eye Matthew eye Nyindam e de 53.47% ena win ye ena eye NDC candidate no eye Daniel Nsala eye Wakpa e de 46.33% ena cheso ono so e de so nese wo hwe gaba ane between omo in eye omo mkoto aba na nese eye between eye almost 4,000 and another say a difference. Now, no, and NDC candidate, no, at the same way, I copy more court to say 2024 election and Casano, and you may be cause one tiasia da because ye two are banning ye coalition. Or call baby at say easy demand ness and your easy assassin, wabra easy yanka baby a coalition, no, and fanchano. And no can't be and all the copy more court. Now, was actually man just say a police station CDBA resource and a buyer over 41 out of a year 152 no could be any just say and near my woman and yano numbers be and add up. And no, and I just saw the copy mo. A year tamale, a high court, just a court. A trema, wash a year easy. Say in the next 30 days, easy and making sure say a year by election and that's a rerun of the election. No, ebebaso. Now, where am a year MP? Say, and that's yes, I quite turn a swab by incumbent MP. No, a year NPP MP, a year Matthew, a year Yindam, Wakasa. Sanso ene NDC omo amonso kopie mo court NDC candidate amonso de ne koye Daniel Nsala Wakpa ono so edi enkomo e wo ho na conversation no very very interesting. Another by election enya sem ketua yetie ensem a NDC after court omudi nsem etuja.
As our case before the court was very simple. We had a rogue electoral commission district electoral officer who decided to abuse discretion. Now, what is important, and that why this case is significant, is that at every district election collation center, there are certain rights that are preserved for the candidates. Now, when the polling station closes, you move to the district collation center, and that's the parliamentary collation center, and certain things can be done there, including asking for a recount of even the polling station. Now, when you say that there are disturbances at the collation center, the law is clear that you either adjourn it to the next day or you can adjourn it even for a week. But you don't relocate the district or redesignate the collation center without notice to the participating candidates. And then you, when you were brought to court, decide that you are going to support one side against the other, making allegations that the petitioner was involved in busing hooligans to the place to come and destroy property and also to engage in acts which were inconsistent with the election laws. When the district election officer was put in the box, he could not even point one, even his own videos, to show that indeed the petitioner had done any of those things. So clearly, our point was very simple. The failure to notify the petitioner of the relocation and redesignation of the collation center meant that clearly there was no way he could have participated in the collation and to be able to exercise his rights, which included serious irregularities which we brought to the court. So in the fairness of the entire thing, including the ample evidence that there was complete destruction of the biometric verification system and all that, the only alternative would be to rerun the election. And so we are very happy that the court has ordered that within 30 days, the election should be rerun. The power and the sovereignty lies with the people. It is for them to decide who their MP is. And you cannot be a beneficiary of such an incident and call yourself an MP. That is out of the question. So the alleged MP, who has now been clearly exposed as not being the MP elect, was a beneficiary of a rigged system by the district election officer. And I will appeal to the petitioner and the NDC election committee to ensure that that district election officer does not return back to that position, because he can cause mayhem in this country if he's allowed to do so.
Nti ano no kyerɛ sɛ NDC ɔmo jubilations after court ho nsɛnsɛm no ɛno ɛna kyerɛ sɛ ɛyɛ NPP ɛyɛ MP sisi a ɔte so ɛyɛ mmɛti ɛyɛ nyindam ɔno nso aba abɛdi nkɔmɔ na wɔso wɔn wɔnte aseɛ because nneɛma bi no asɛ nneɛma bi nhyɛ da nye yie nti ɔmo kɔ appeal because ɛyɛ den ɛna kyerɛ sɛ wo challenge ɛyɛ 41 police stations a wotumi ka sɛ yɛnkɔto ɔba ne nyinaa foforɔ ɛsɛ nneɛma bi wɔ hɔ no ma wɔnhyɛ da nte aseɛ wɔdi nkɔmɔ ɛde nsɛm
Well, let me in the first place thank my supporters, thank the good people of Kpandai, and let me put it on record that I'm still their MP. Yes. I want to put it on record that I'm still their MP. Although, like the lawyer said, we were in court, and before we came to court, I can say for sure that for about a week, we knew that things were not going to be right. Our opponents were jubilating. They were saying all manner of things in Kpandai. And they were too sure that this is the judgment they were going to get. But as law-abiding citizens, I want to put on record that, yes, we respect what the judge has said. We vehemently disagree with him. I know that I won the election with a difference of 3,734. That is a clear victory. And if you look at the pink sheets, it's on record that they've admitted that every single pink sheet was given to all the political parties. I have my 152 pink sheets. They have their 152 pink sheets. And if you put the results together, we have won the elections. For some reasons, powers that may be, they decided to come to court and knowing very well that maybe they'll be able to use the state's powers to overturn certain things. But I think that we are in a country that is governed by laws. And that is why the courts are arranged from a lower level to a higher level. So that when a ruling is given at a lower level and you disagree, you move to the next level, which we have done this time. We have completely filed our stay of execution. The lawyer has done that. He's filed the appeal to as well. And we think that God being so good, the next is ours. I'm not afraid, let me put on record that for a run. You see, if genuinely we have to run, we won't have a problem. But if you decide to pave your way through because you think that you are in government and you can use state powers to be able to coerce the people to vote for you, that's where we have a difficulty. In any case, he came to court with 41 polling stations. And these 41 polling stations are areas that I won with huge margins. But they realized that if they get the judgment for even the 41 police station, they were going to lose it straight away. So for whatever reason, the judge said that we're going to have a rerun. But we respect it. We have gone to the appeal court. We filed stay of execution, and we will take it from there. It is an interesting story, okay? Because it has never happened before. This is the first time something like this has happened in Ghana. And it should tell all of us that we are not safe. We are not safe. We need to sit up as a nation, because if the executive can directly come and you saw the court today, even the regional minister himself was in court. Almost everybody who matters was in court, and that completely told me that Yale, what you are sensing is what is going to happen.
Granted, we believe that the petition was frivolous, but the court has decided otherwise. So we respect the decision of the court, but we strongly disagree with the judgment, and we have already shown our agreement by filing a competent notice of appeal, and we've added a motion for stay of execution. As a lawyer, if you have picked certain information that judgment will be compromised, you prepare. So you come for the judgment with a notice of appeal in your pocket. And that was exactly the decision that is affirmed, because we knew that was what was going to happen. So it's not even surprising at all. And so the only fight left for us is to follow the due process of the law. And that is by filing a notice of appeal. This is my notice of appeal dated 24th November 2025 at 10:04. The motion for stay of execution is dated 10:13. Now, the petitioner has been served with the process and he decided to throw it away. But that's proper service. In law, If they serve you a process and you throw it away, the bailiff will only go and prove service by saying that you were served, but you threw the process away. And that's even contempt of court, but that's for another day. But all I want to say is that we have accepted the decision, we respect it, but we disagree. And that is why we are marching forward to the Court of Appeal, where we believe that they will review the evidence on the record. For example, the record is that every was given a copy of the pink sheet.
Eno ene chese Matthew Enyindam ono so ensem odi to dwa MP for Kpandai Constituency a chese by election anasa rerun ese ba bekoso ewo constituency honom e dia yam hye abrem krofo bi aha Dowona TV chwawem e comment section